Hi, friends. Want to welcome you to our live. And today we're going to be talking about J-1 waivers in 2025. We're going to talk about some of the latest questions that we've been getting about J-1 waivers. I want to thank you all for joining. When you join, please let us know where you are commenting from. It's been a crazy, crazy year with immigration law. And I can't believe that the year is almost over. And we're going to continue to keep you informed with what is happening now and what's happening with the latest in immigration law. Specifically, today's topic is going to be J-1 waivers. So when you join, let us know where you're from. And we want to thank everyone for joining this live cast. So let's dive into it. So the first question that we have is, why do you need a J-1 waiver? Well, if you've come in on a J-1 visa and you are subjected to the 2-year home residency requirement, then you need a waiver to overcome that. You either need to go back for 2 years or you need a waiver to be able to stay in the United States. So you might be wondering, okay, well, what kind of waiver do I need? Do I qualify for that waiver? Is it worth applying for a waiver? Well, those are all really great questions, and we are getting waivers approved despite this new administration, despite the fact that immigration and enforcement have increased with this administration. Let's talk about the different types of waivers that you may qualify for. So the ones that we do in our office the most of are hardship and persecution. So that's showing exceptional hardship to a U.S. citizen spouse, lawful permanent resident spouse, or a U.S. citizen child or lawful permanent resident child. So those are the most common types that we do. Those, and you have to have those qualifying relatives in order to just be able to qualify. So we've seen like very smart, talented people make that basic mistake where they file because they had a U.S. citizen parent. So you want to make sure you don't make that kind of mistake. Another type of waiver is a no objection waiver. If you get a no objection statement from your home country, these are getting much, much more challenging to get approved. The Department of State is denying many of these now, whereas before you had a no objection statement and it was more likely that you would get your case approved. Now, overall, we're getting many calls from people who are getting denials, even though they have the no objection statement. So a majority of those are now currently getting denied from what we're seeing from the feedback that we're getting. And for physicians, there's the Conrad 30 waiver where you work in an underserved area for 3 years. That is a very common type of waiver for physicians. Many physicians prefer the exceptional hardship waiver because they don't have to work in that underserved area for 3 years. But you may not qualify for the exceptional hardship waiver. So then you may want to look at that Conrad 30. There's also the VA waiver as well, where you work in at a VA hospital or a medical facility. And welcome to those of you who are just joining. My name is Coach Ranchod. I'm from the Ranchod Law Group. Been practicing over 23 years, and I invite you to let us know where you are viewing from. And you can also post your questions. Today's topic is what's happening in 2025 with J-1 waivers and some of the most frequently asked questions that we've been getting. We're addressing those right now. We're talking about J-1, different types of J-1 waivers. So we've talked about the exceptional hardship. We've talked about we haven't gotten into persecution. We talked about the no objection. We talked about the Conrad 30. Persecution, if you would be persecuted if you go back to your home country. Some examples might be based off of religion or political beliefs. You might be eligible to apply for a persecution waiver as well. And then there's also a variety of interested government agency waivers as well. So you can see there's not just one path to getting a J-1 waiver, there's a multitude of paths. All right, we have another question here about how long is it taking for an exceptional hardship waiver? Well, exceptional hardship waivers right now, we're getting cases approved anywhere from 1.5 years to 2 years. USCIS is posting 21.5 months on their website. And keep in mind that it also takes time for the Department of State to process as well. So with the exceptional hardship waiver, first it goes to USCIS. They will review the case, make a recommendation, issue I-613, then it'll be forwarded to the Department of State, and then the Department of State will make their final decision. And in that, the Department of State can take anywhere from a month onwards. Welcome to all those who are joining right now, and you can post your comments or questions and let us know where you are viewing from. Always like to see that. And we're talking about today's topic is J-1 waivers. Okay, so if no objection waivers are faster than the exceptional hardship waiver, and Conrad 30 waivers are also faster than the exceptional hardship waiver as well. All right, next question that we have is, can you apply for a green card after getting the J-1 waiver? What do you do after getting the J-1 waiver? This is a really important question because sometimes many of you, or some of you might think that, oh, I got the J-1 waiver, I'm set. Well, you still have to apply for a green card or some form of lawful status to stay in the United States. You cannot just, the J-1 waiver does not provide you with a lawful status. What it does is it allows you to stay in the United States if you get a lawful status. So it removes that 2-year home residency requirement. So some examples of what you would do next is apply for H-1B visa, or if you're married to a U.S. citizen, apply for a marriage-based green card, or apply for a national interest waiver. You could apply for the I-140 petition before, while you're doing the J-1 waiver, but you can't go on to the 485. So it's not recommended that you file for the green card while you have the J-1 waiver pending. The current trend right now with USCIS is that they are denying green card applications if you haven't met the 2-year home residency requirement. And even if you apply for the waiver while the green card and file for the green card application at the same time, what we're seeing is that USCIS may deny those cases because they, in some situations, are stating that you weren't eligible at the time of filing the case. And next question is, why would a J-1 waiver application be denied? Well, there's a variety of reasons. One is not having enough documentation. What I see happen is that people think that just making the argument or the statement is enough. It's not. You have to back up everything that is stated in the statement with evidence. And you also need to have very strong evidence as well. So for instance, if you're gonna have a medical claim, medical records plus a doctor's letter, they love to see doctor's letters. So a doctor's letter is very helpful. If you have a mental health hardship, a mental health diagnosis from a professional. Those are some examples of strong forms of evidence. Also, not communicating the narrative, not articulating it well, having a poorly articulated narrative. These cases, exceptional hardship, are some of the most difficult cases to get approved, and they need to be communicated very, very well. And that is where it's helpful to have someone who specializes in J-1 waivers to help you with that, in making sure that you provide a well-articulated narrative. If you do also have questions and you want to dive into whether or not your case qualifies, could reach us at 916-613-3553. And you can also post your, if you have comments here as well. One of the other big mistakes that I see with exceptional hardship waivers is where only one of the arguments that is needed is made. So what do I mean by that? Well, you have to show that there would be an exceptional hardship if you were separated or if the U.S. citizen was going to accompany you. So sometimes what I see is that the argument is just made where the U.S. citizen is going to accompany to the home country, but not with separation. So you have to show exceptional hardship in both situations. What USCIS likes to do is point that out and say, well, you didn't show that there was hardship with separation, even though you met the hardship when if your U.S. citizen qualifying relative was going to accompany you. And it's very important that you make both of these arguments and not just one of them. Okay, well, I want to thank everyone for joining. That's going to be a wrap right now for today. And we are going to continue to have these live. So I hope that you did find this helpful. And make sure you stay tuned for future lives that are going to be coming up. And if you do have questions that you would like to deep dive into this in more detail, you can reach out to us at 916-613-3553. Thanks. Bye for now.